A very warm welcome in the fifth module of week 7 of the course Roadmap for Patent Creation, titled Interaction with IP Attorney, Initial Drafting, FER Reply and Hearing. The most important step in patent filing is selecting a competent patent attorney. In first live interactive session, that is on 1st March 2019, there were two queries referring to this topic. The first query was how to identify a trustworthy patent attorney, and the second query was what is the difference between patent agent and patent attorney. So, here briefly I will clarify the second doubt, and for the first doubt, when you will go through the whole module, you will get idea about how to choose a trustworthy patent attorney. Okay. But to first thing, that is, most of the time means you need not to worry about the trustworthy thing, because it is a professional ethics are followed by everybody. Okay. So, what is the difference between this patent agent and patent attorney? When we are dealing with a patent, I have already clarified that there are three different things, that is a sections you can say: patent analytics, second is a drafting and prosecution, and third, that is a patent litigation. Now, this patent analytics part is there. For that, you will not require any law background or no patent agent examination. If you are having science and technology background, you can be a good patent analytics if you do the practice in that area. So, that is a patent analytics part. The second, that is a middle one, what we are talking about, a drafting and prosecution. Here it is compulsory that you should clear patent agent examination, which is conducted by Patent Office of India. That is a compulsory. Without that, you cannot practice drafting and prosecution part. Okay, that is a second. The third thing, that is a litigation part, is there. For the litigation, obviously you will require a law background, but not necessary that you should have a patent agent qualification, because when you are doing a litigation, you are working in a court of law. When you are a patent agent, you are working with the patent office. So, for patent office, patent agent examination is must. For court of law, obviously LLB and the bar examination is compulsory. You have to qualify. You should be you should have that law degree, and you should have qualified that bar examination. Unless until that qualification is there, you will not able to practice in a court of law. So, this is what the patent attorney, when we say lawyer and patent attorney, generally the minor difference is that you may have a law degree, but you may not have qualified a bar examination. That again the important thing is there. So, you can now understand that what is that patent agent is there, what is who is like a patent attorney is there, who can do a patent analytics. Now, moving further, we will see in this module what I will do, that to avoid all this confusion about patent agent, patent analyst and patent attorney or patent lawyer. Okay, all these terms that will come. I will use a simple term, that is a one term, that is a patent expert. He may be patent analyst, he may be a patent agent, he may be a patent attorney, he may be a patent lawyer. Okay. So, I will just say a patent expert here. Now, so patent expert, he or she is the one who will determine whether your invention is patentable. That is the most important thing. He or she will help you to obtain appropriate patent protection for your invention. Appropriate in a sense that whatever your invention is there, everything is covered in the patent document, claims are drafted accordingly, and complete protection is provided to your invention. Also, he or she will help you to create path for commercialization, which may be in any mode, as licensing, entrepreneurship, collaboration, anything. In one of the module, that is we have dedicated one module on the commercialization. Then for patentability, we have dedicated module in week 2. For patent filing and process, we have dedicated modules in week 5 and week 6, right. This commercialization module is in week 8. So, you can visit that thing to get idea about these particular aspects, but it is expected that he will or she will help you in the whole process, right from that idea stage to commercialization stage. He may be expert in one of the area, but at least he or she will guide you that okay, for commercialization what exactly can be done, or he should think, it is rather expected that he or she should think thoroughly when he is filing a patent, he is drafting a patent, he should think all this area, like right from that first thing to that commercialization, all aspects should be taken into consideration, and that will be considered when claim drafting is done. That will help you to give the wholesome complete protection of your invention, because many times what happen, you think in one direction only. It is a duty of attorney to ask you question. Patent expert will ask you a question that will trigger a thought process in your mind, and you will start thinking, oh, my application, I was just thinking in this area only, now this can be the area which I can explore, and this is applicable to that also. So that kind of, what we can say, a thought process should be initiated by a patent expert. That is important, right? So you have now a good idea about the subject, right, about a patent and all kind of procedures and forms and filing and all these tools, everything you know now. This filing process, it is starting from generation, protection and commercialization. After getting this basic idea about patent expert and what is that patent cycle is, the first question is where I can find the information about patent expert, whether there are any resources available. So here the few resources are definitely available. So let us check this. Generally, the starting point will be your friends who are working in IP area or law area. So you can inquire with them, and then you can discuss with them to find out the person who is working in IP area. That will be your obviously first contact. Then you will try to get information from your friends who have already filed patent, right? So their experience and all that, you will just explore that thing and you will get the idea. Then the very common source will be obviously internet browsing. That will also give you the pretty well exposure that who are there working in IP area. So these are the general starting points for obtaining the information about a patent experts. Bar Association also can provide you information about this patent attorneys and patent experts, right? That is anybody, means patent agent or patent attorney, that information can be made available through them. However, good resource will be Indian Patent Office site. On the website, if you visit, anyone can visit that site and get the details about a registered patent agents. You can get a list of registered patent agents. So in one go, you will get a good, what we can say, a perfect list of who are the patent agents, who are these patent agents working in which area, means you can get address, you can get all details about a patent agent from that site. Now there is one more thing is also available on a patent office site, that is a patent facilitators. So this information also you can get from the patent office side. I will not go in details of patent facilitators, but this is the what we can say, the facility which is made available by Indian patent site. These patent facilitators will help you to file a patent, and this came through the various projects like Startup India and all kind of projects that help to develop this patent facilitators. So you can get that information on a website. Now thus you will get now the, what we can say, a good data about a patent experts here. Moving further, now you have a good data now, so you have to choose now. You have received information about patent experts. Now you will be now confused, okay, who will be the best for my particular project. So how you can do that, what we can say, assessing for choosing the patent expert. Now what the thing is happening, this patent process, you know that it is a domain specific process. No single person, remember this thing, not a single person can file patent in all subject areas. It is not possible. With the practice, definitely patent expert can file patent in varied domain, right? Still there will be a few areas which he or she will not comfortable. So when you will interact with patent expert, please check the area of expertise of patent expert. He or she will clearly mention that she is expert or she is very comfortable with a particular area of technology. For example, if this pharma or chemistry field is there, that will require expertise in chemical structures or related knowledge. Computer engineering will require knowledge related to that computer engineering. Microbiology and biotechnology, if you see that areas, that will require again a different expertise. So we can say that broadly life sciences, chemical sciences, computer sciences and so on. So many times because of many years of practice or experience, patent expert can work in areas other than their specific whatever the specification is there, but that must be judged properly. So in short, your subject of invention and expertise should match. That is the first important factor while considering a patent expert service. Now, moving further, what should be the education background of patent expert? That is again the next question. It is important to know the technical and scientific educational background as well as a legal education of and a patent experience of a patent expert, both in terms of years of experience and the nature of experience. Remember, IP is a interdisciplinary subject. We say that it will be good if patent expert will have law background, technical background and management background, because that will give you that the complete holistic background, that complete holistic idea about a particular subject. So if patent agent or I will say now the patent expert to whom you are now contacting, just check a legal background, whether he is having a legal background, because that will give some added advantage, because he will think, oh, if that particular patent, if go for the litigation, what should be the things, right? And considering that, anticipating that factor, the draft will be done, means your draft will be drafted, patent draft will be created. So that is the one thing. Patent agent, obviously it will help you because he is the person who know patent law thoroughly. So compulsory he should have that degree, that is a must thing. You should check that thing whether he is a registered patent agent. That is again most important thing. For registration he has to qualify that exam, he has to give character certificate and then he has to give particular fee, and then only registration happen on the Patent India site, right? So he has to do all that things. So you have to check whether he has qualified that patent agent examination. That is the most important. So this is particularly what we can say legal point of view you are taking the consideration. Now technical background. Obviously first you will check a subject, but again you have to check how the person is good in that particular subject area. You have to judge that thing. Generally, if a person is having a what we can say a degree, means advanced degree, obviously masters, or if a PhD degree in particular domain, definitely that will be added advantage. That will be added advantage. But obviously, you have to check that particular background. That will give you the idea about a technical, what we can say, background of the patent expert. That is that. Why I am saying a management background? Because see, you are filing patent for what? You have to commercialize it. So when you have to commercialize that particular patent, if somebody is having management background, he can think thoroughly, okay, what will be the next step, how he can explore this particular patent further, and he can give you the idea that okay, he can strategize your patent filing process. Obviously that is very important. Though I have said that you have to file a examination request right with that particular complete filing only, but there are so many things that you need to be strategized, that there may be possibility that it may not be good to file a request for examination at that time. So all that kind of thing, that strategizing your activity, if you have that management background, you think in a different way. So a person having this three background will definitely give you a perfect, what we can say, the draft for your particular invention. So you can check that thing, but not, remember, not necessary that education will define everything, because with the practice, with the experience, right? If that person is having an experience, he has built up that experience, he will be again, because of experience, he will guide you perfectly, right? So experience and education, both things you should check thoroughly, and then you can decide. So subject, experience, and what we can say the education, that will help you to choose. So here when you go through the patent drafting, that will be a drafting and prosecution part will be there, then searching part will be there, then litigation part will be there, then commercialization part is there. If someone who is good in all these things, nothing like that, because he will know your all steps very thoroughly and he can handle things very, what we can say, easily when when he will draft the thing, right. But you should check down, because it is not necessary that person who is good in patent drafting, he may not be good in searching. There may be a rare case that the person is good in searching also, good in drafting also, good in commercialization also, he is good in litigation also. That is very rare case. And remember, your patent most of the time it will not go for a litigation. We have already shared with you that generally that litigation, when litigation comes, that section 3 against, if you want to go that particular, if something is related to that at that time, and then infringement case if is there. But if infringement case is there, a tip is that don't go in a court of law, amicably you just settle down the things outside the court. That will be the best way to do the, what we can say, to go ahead. So, if any infringement is there, but obviously it depends on the, it's a very general statement, it will be, you have to check the scenario, under which scenario the particular dispute is arise, right. So, all these things are there. So, your patent expert should know or aware about all these things. Okay. Now, after going through this background, next important thing is that there are sequence of events for filing a patent application. For example, and that you should be prepared for that sequence, right. Attorney will recommend you a patentability search. Then based on that result, the preparation or filing of patent application is there. At least I will suggest that without search report, you should not file a patent. If your search report is negative, whatever the amount you are investing for that filing, drafting, it is a complete waste, because it will never get granted. So, you should check that, you should be aware about a search report. That is a that I at least recommend that thing, right. And I find it very important to have a search report. After search report, if search report is positive, obviously that 18 months window is there, that is like a black box, nobody can give guarantee about that thing. But at least you will get idea, okay, before that at least the scenario is that, okay, my invention is novel or not, that pretty well idea it will be given by search report. Then there will be a patent drafting. In that you have to define the scope of the draft. So, here when you are discussing with a patent expert, it is better that you discuss thoroughly your invention, so that he is the best person to define the scope. You are not, you may miss something. So, better discuss thoroughly the scope, means invention. You need not to think about the scope, patent expert will take care of that thing, that he will define, he can broaden that. Broadening that scope of your invention is most important, and that is a job of a patent expert. He should help you in that thing. Now, then if you have to check whether capability is there to, if I think of international protection, whether this patent expert will help me to do that kind of thing, right. So, whether he is having that established relations or associates available in other countries, that is a most important thing. And again the important factor is whether they are charging reasonably, because when you are filing patent in USA or Europe, it is a very costly thing. So, you have to check down that whether that quality representation is available through the patent attorney. Okay. Now, then the next, probably the next step in future is coming like a agreement thing. So, you have to check whether that help in that commercialization or license agreement, whether he is capable of providing that thing. But it is like a very ideal situation. There will be a few people who can do all this thing, but that license agreement also, and search report also, and they are having associate also. But the thing is that if that patent agent or patent expert, if he is not having all this in one thing, means in one stop, if it is not available, at least that network should be there, so that you will not, what we can say, you will get some guidelines and you will not get lost in this process. So, if you have to just check whether he will help in all these processes, right, because timelines and everything is important there, and you should not miss on that thing. So, you will check that subject expertise, then you will check into consideration that project under consideration, you are going to check educational background, then you will consider that sequence of event, and then the next will be the financial matter. That is again the most important thing. You should know what is the fee that patent expert is charging. So, attorney fee, whether there is a hourly rate charged or it is a lump sum amount. I will suggest that don't go with that. If any attorney means most of the attorneys they will charge, means there is a practice, it depends on attorney. Hourly rate is there, fixed fee is there. So both modes are available. So it depends on you. If you are thinking, if you are meeting attorney on hourly rate, you should be very prepared and you should be decided that okay, this questions and this answer. So your preparation is most important when you are meeting a attorney on hourly rate. If a fixed fee is there, then that will be comfortable for you. If you are handling this patent things first time, fixed fee will be the best thing. Next thing is that you should check about the disbursements, right? When you have to give fee, at what stages, because we have seen that there are various stages. First is a search report, then there is a provisional if you are taking help of a patent attorney, although I am suggesting it is not necessary, you yourself can file. But for complete specification you will need help of patent attorney, that is a second stage. Next is like a FER response, probably you will not able to write, again you will require help of a patent expert. Hearing, again you will require an expert. So these are the at least 4 important stages you will require help of patent expert, and you should take help of that if you are very sure about your invention, because he will do justification to your invention. So you have to choose that person very carefully, and then again of course you have to think of a fees also, right? So you should ask at what point how much fee I have to give, whole this process how much I have to charge. You should know that thing, right? And you should know about the statutory fee also. You have to remember about a maintenance fee also. So when you are planning filing patent, you should think thoroughly till the commercialization, that end till that end you have to think, right? And then after fee you should ask about the timings, because if they are so busy, they may your filing process will be delayed. So you have to check about the timelines, that when you will file my patent, at what will be the means how much time you will take to draft a patent. All that thing you should discuss and you should understand that thing, and obviously you should assist, means you should be very cooperative in that process, because many times what happen, the attorney try to contact you, you may be busy but you may not call back again. Make sure that if any patent expert or attorney is calling you, he is in the process of writing, immediately reply him, so that in that whole means once he start a process, you should help him so that the process will be smooth, right? Don't avoid the calls or means whatever time is there, you just make sure that you will communicate with the attorney, right? Now next is that after that you are getting this, now you are getting idea about expert and then fees and then timelines and everything you know. Then again there are a few what we can say things that are very important. The most important is the comfort level of an inventor with a particular patent expert. Now I can just share you a experience. What happened that generally in a law firm, if you see, there are so many patent experts. Many times what happen, if 4 ABCD law experts are there, you may be comfortable with they are working in all these things are matching with all requirements, subject and everything, but possibility is that you will be comfortable with one of them, right? So that comfort level is very important, because patent process is like a two-way process. You are discussing that thing and then only it will come out nicely. So that comfort level is important. So you have to check that also. It's very minor thing but important thing. Extent to which the inventor is able to assist and desire to participate actively, that is important. Many times what happen, institute, for example, institute communicate with the patent attorney. Inventor is busy, professors are busy. So that gap might come, that professor and the attorney. So there should not be any gap in that way. You should be in directly contact with the patent attorney who is drafting your patent. If he calls you anytime, you just give a reply to him, because he is writing the thing and in that thought process you are helping him. So make sure that that communication is there. So both parties are involved and both parties should cooperate with each other. Now after getting this much, that the major issues, then some that minor things, that minor points, again a few important points are related to the application legal point of view. The first important factor is a decision of inventorship and assignee. So here again the most important thing, when patent is commercialized, you are getting money. If you will not decide on inventorship and assignee at this time, that is a filing time, you may attract litigation. There will be a conflict of what we can say in the part, means if you are an inventor and assignee, and if you are not aware who is owning and what, and we have, because of that only we have dedicated one complete module on inventorship and who is assignee and who is inventor and what are their rights. So you know now that inventor is like he is who have invented, right, but assignee is a person who is actually getting the rights, who is a person, the owner of that patent. And now again the important thing is, if you are in an academic institute, what happened, there are maybe 4 inventors working, 1 professor or 2 professor, 2 students, that kind of combination is there. Better thing is, at the filing of patent only you should clear that how much percentage of work has been contributed by each person, right. That will make you in the sharing of a revenue or royalty in the later stages. Although you will feel very odd in the starting point, but it is always better to do that, right, to avoid any conflict in the later stages, because it will be then again headache for you in a later stage. So better prepared in the first stage only. Be practical in that point, be practical on that point, and complete that processes when you are filing a patent only. Okay. Now you should, so you should decide who is the inventor, then you should that availability of inventor and all that thing, that is again important. Who is applicant, that you should decide, and we know the 3 types. So you should be very aware, we should aware about that thing. Individual is there, then MSME category is there, and then other categories there, and you should be very careful. You should take decision in which category you are filing, because fee is different in all these 3 stages. Okay. Now after moving further, means what the thing is that policy of organization obviously define that inventorship and assigneship, and documents will prove that eligibility of applicant. So all that documentation is very important. Once everything is finalized, obviously you should create a form 26, right, where you are giving the authority to patent expert to do work on behalf of you, right. Now the next important part is the features of invention. You should thoroughly discuss the technical features, and experimental data should be provided. Crucial information related to that invention, you should provide it to the expert, right. Now here, that which are the technical features that inventor consider to be essential vis-a-vis the known state of the art, that is important. Then is the invention predominantly a product or a process, that you should determine. Which are the advantages because of that invention, that should be determined. What are the disadvantages or what are the problems of the prior art, that should be discussed. Then whether prototype is ready or not, that related discussion should be there. Then whether further experiments are necessary, if that kind of thing is there, he will keep in mind, okay, there is a possibility of a patent of addition. So you should think of, you should clarify that thing also when you are discussing with a patent. Then he will also ask you whether you have commercialized that product, whether you have disclosed it in the lectures or presentation, whether the manuscript is published. All these questions attorney will ask you. So don't get offended by the questions of attorney, because he is trying to establish a patentability. So he will ask you question, just cooperate with him. Okay. Then based on the, if you have done any research on the that prior literature review and all that thing, please share it with the patent attorney so that he can get the idea, okay, this kind of research is available. Then does invention have any connections to existing product, because sometimes you should clearly say that, okay, I have derived this thing from this product, or this process was a motivation for me, so that he will check that process clearly, and so he can avoid any novelty related what we can say conflict, if there are, he can directly focus on that particular point. So you have to just check or share that thing. Then what modification exactly you have done, then whether there are any alternate sources you have explored. Okay, all these things, whatever the minor things are there, you should share. Then also you should share that whether you have communicated with third parties, or that third party is going to do publication of that thing. All that thing help you this patent expert to strategize the whole process of a patent filing. Okay. So the next report after that, means all this discussion will help you to build up the, what we can say, he can get the idea about your invention. Next he will do the search report. Now, the most relevant prior art he will just dig out, he will share with you, he may ask you, give me the differences, and it is your duty that immediately you should clear that okay, this is this invention or this patent is saying to me, and this is the difference between my invention and this prior art. So, you should cooperate in that way. Then if required, he can do a supplementary search. Okay. So, after going to that search report, then the next is a use of a patent or application. You will share some particular applications. Now, your patent is giving you a monopoly, right? Now, here a specific product or process will be marketed. So, claims should be drafted in such a way that the broad scope will be taken from that description and a claim drafting. So, here you should cooperate and discuss in detail what will be the application, so that patent expert, being an expert in that subject, and because of his experience, he will help you. Okay, you can think of whether this domain means this sector, because you might have think of one sector only. He can give you idea about okay, can you help in can this will be applied in other sector and all kind of thing. So, always that discussion will help. Then also that discussion will help you to define a market, because maybe you are not interested to file patent only in India, you want to you have to file maybe in other countries. So, here only you should decide whether you will take a PCT route or you will file a convention application. That discussion also you should do in this phase only, and if you are aware about a market and your strategy is very clear, then obviously you will choose the conventional application. So, patent expert will help you to determine that path particularly. So, whatever we have learned in week 1 means week where we have seen the IP identification tool, you just think of that IP identification tool and just apply that thing, right, and then discuss accordingly with the patent expert. Now, there will be a special case also, right, inventions in biotechnology, if it is there, then we know that deposition of that culture is very important. Then you have to, whether that use of constructs or organisms which are not publicly accessible, then that also you should clarify, and that also you should discuss with the patent attorney. Whether the constructs or organism have been deposited, that is very important, because timeline is there, within that time you have to deposit the culture in NCCS or that MTCC, right. So, you have to do that thing. If the inventions are related to chemistry, chemical substance, chemical processes, whether what is a method of synthesis, which are the compound, whether there is a mere admixture, all that things you should discuss it with a patent expert. Then apply a patentability tool, right. You can refer week 4 module for this, and you can just get idea about we have seen in the patentability tool that criteria are there, novelty aspect, non-obviousness aspect, industrial use, stability, then that confidentiality aspect, and there also we have given you idea about that how the search report is done, what are the different documents which are explored or gone through during that thing. So, you can apply that thing. If you have done that thing, that thorough what we can say analysis about your invention, it will be easier for you to interact with a patent attorney, right. Then the draft evaluation is there. So, again we have seen, we have dedicated module on what are the different parts of a patent document. Here you know which are the different parts. So, you have to clarify here that you have to very clear, now you should be very clear what is that invention is, whether my invention is patentable, then disclosure kind of thing. So, everything whatever we have seen in that tool, right, everything you have to just check, and you have to see whether my invention is really following all that particular things which are mentioned in that patentability tool. Now, after that means you have to decide on whether you are filing a provisional patent or a complete specification, that also you have to think. And then after that you are aware about a title, then preamble, technical field, background, then object, what is a brief description of drawings, what is a detailed description, that all parts you are well aware of that thing. So, you can just think about all this, your invention, and what can be possible. Obviously, patent attorney he is drafting. So, one more important thing, you will not, when you are giving the job to patent attorney, you will not invest your time in writing the sentences. You can just give a bullet points. It is a job of patent expert to nicely write it, because he, anyway you give in any sentence format, he is going to change it. So why should you invest time on that same thing, right? So you can just give in a bullet forms all the details whatever required. What details you have to give, that whatever the parts of patent documents are there, that will help you to give you the guidelines. Okay, I have to give this thing, that will help patent expert to draft a patent. Don't waste your time in writing patent yourself, because already patent expert is doing that job, and he will do the job perfectly for you, because he is having practice in that domain, right? He is doing that activity continuously, and so he will completely convert your document into that techno-legal document perfectly, right? Now, moving further, after that, once you have communicated everything with the patent attorney, you have done the drafting, how to choose, everything we have seen. You have done filed the patent. Now the next thing will come is a first examination report. So once you file a patent, probably 2 years, 3 years, you may not be in contact with attorney. Suddenly after 3 years, he will communicate with you, oh, your examination report is came now. So he will share with you the first examination report. If that report come, remember only 6 months are there in your hand. If you want patent little bit early, you just cooperate with a patent expert. If he asks you questions, you just give answers to that, so that he can prepare a reply for that first examination report, right? So that way he can draft, he can show you the first examination, that what is the reply he has drafted against the queries. Again, what the thing happened, don't get confused or get a little bit, what we can say, nervous because of first examination report. Because if you see first examination report, it is like many times you feel nervous, because examiner will ask you so many questions in the first examination report, and you will feel that, oh, I have done so nice work, that invention is very good, but still so many queries are there. So don't worry about that thing, patent expert will take care of that. Just cooperate with him and he will take care of that thing. Now the next thing, the last thing is coming, that is a hearing. So after giving that first examination report, the next thing will be the hearing notice if required. Means if your examination report, if that examiner is happy with your report, probably he will grant, but generally he will expect you to have some discussion with you, so that if any queries are there, he will clarify that thing. So after 6 months, 7 months, or maybe year, once you file that examination report, again a patent expert will communicate with you that hearing is scheduled, right? That kind of thing is there. So at that time, again, if he will have any queries, he will just share with you. Your mobile number should always be with patent expert, because he can contact you. If any queries are there, he can communicate with you, and you can just give inputs to him, so that hearing can go well when he will attend that thing, right? So that is a hearing, and you know now first examination report, hearing and everything, right? Now after this hearing and then first examination report, mostly you are completed all the processes. If everything is, what we can say, in perfect way, obviously the patent will be granted. So whole process is there, and your your communication with a patent attorney is important. So now you know that, okay, that how you are going to choose patent attorney, what discussion you should do, what factors you will check when you are choosing a patent attorney, the fee and the timeline and what to be communicated, all that thing, right? So here now, after going through that all these things, you have got, I guess, pretty well idea about the how to choose trustworthy patent attorney. That was the question. So how to choose a patent attorney? The professionals are always they are following the ethics, so don't worry about a trustworthiness. Okay, please watch this video, what patent expert is saying about interaction with a patent attorney.
I'm Malti Lakshmi Kumaran, and I'm a life science expert. My PhD is actually in biotechnology, but I've moved into the area of patenting, and I'm a registered patent agent as well. Our work in the law firm is actually to mine a lot of inventions, draft patent applications, and prosecute the patent applications till it comes to grant. So this is what I generally work with. The first thing that I do interactions is with the inventors is to see what is their patent, what is their inventions, how can I patent their inventions, and it is a two-way process. I keep talking to them, understanding the invention, trying to read a little about it before we ask them questions in the subject. Once they are through with this question answer questioning, and when we question them, they give us the answers. But many times we find with the inventors, they're able to tell us about their invention. But then the question of the patent attorney is to ask the right questions. Questions is, what is the problem that is there, that is being faced, and how did you with your inventions solve this problem? So that is where we come in. So if you ask the right questions, they will be able to give you the right answers, and then we make them comfortable. Once this is there, it goes through 2 or 3 iterations between the drafters and also the inventors. Once we are clear about it, we draft the claims, and then we draft the specification, and then we submit it at the patent office. Till this stage, it is very nice. But after a couple of years, the patent office then comes up with the first examination report. So the patent office looks at the draft, looks at our specification, looks at the claims. The claim is what is the techno-legal part of the whole specification or the application, as I may say. And he will come and say there are 4 or 5 citations which says it destroys your novelty, there is no inventor step, there is no enablement, or there is no clarity. Many times we then report it to the inventors, and they do get offended. They get offended and they say, oh, it was such a nice invention, how come the controller is asking such questions and also citing some prior art which actually destroys the novelty of their invention. And so our work as a patent attorney is to explain the whole process to the inventors, calm them down and explain properly and say, yes, the controller has every right to question the invention based on novelty and inventor step. And our work is to run through the examination report and clearly identify the differences of our invention vis-a-vis the citations cited by the controller. Once we've done that and we've shown the differences, I've seen many inventors feel very nice about it. So really our duty as patent agents is to really help the inventors solve their problem by trying to get over all the citations and get the patent granted. It's not so easy many times. And the next step that happens is we give our answer, that is called as a response to the first examination report. The controller may accept our arguments and grant the patent. Sometimes he may not. He will ask us for a hearing or also provide or communicate with us with a second examination report. And he may continue and say, I'm not happy with your arguments, provided to get over the objections, and he may give a further citations or he may accept. Now when he doesn't accept our arguments to get over novelty inventor step, what we then do is to have a hearing. He may give us a hearing or a second examination report. It's again time for us to meet with the inventors either by a call, by a Skype or a one-to-one meeting, explain it. We keep all our things rebuttal. If we have to amend the claims, we amend the claims, and then we go prepared for the hearing. So many times we feel that as patent attorneys, we need to motivate. We need to give them, handhold them and tell them that this is an important process. And many of them, I find inventors are very happy. Just like serial entrepreneurs, I've also seen people who are serial inventors. Why? Because they've got into the system, they've got into the groove of actually coming and applying for the patents, getting the patents. And once the patent is granted, then it becomes like wealth for them. One, they can put it into their CV and say that they have a patent, just like a publication, or they can also go and license it. They can sell their inventions and it becomes like a good award for them. I've seen many times the Government of India awarding inventors for the best award for an invention, and that gives them motivation for them to invent more and more, come up with more patent applications than they're able, and it actually drives them to do better inventions. If you have a paper, it's good, scientifically very good, but I've seen they have a better motivation to come up with more inventions when they get a patent in their name. And so this is where we try to work with the inventors and with the companies to understand. Many times we have to tell them don't publish, because a lot of the times the inventors get an award or they get a promotion based on their publication, looking at the impact factor. But when it is a patent, they don't really understand. So we as patent attorneys have to help them to go through this process, motivate them and tell them that you patent first, and the very next day they can go for publication. So this way they get their patent rights and they also get their publication. So this is where attorneys come in to explain the whole process, soothe them and make them comfortable in the whole patent process. Thank you.
With this, we come to the end of this session. See you in the next session. Thank you.